And thank you all for joining us this afternoon for our very first webinar on force majeure in the time of COVID-19. I'd like to start by saying that this has been an incredibly anxious and stressful time for a number of people. People are feeling anxious not just about the South African economy, but the global economy and what it all means for them, their job security and their futures in this new world that we know so little about. And I'd like to say that we have professed for the last 9 years that service is our highest value and that we are the hashtag conveyancers that care. And I want to stand by that and say to you that right now we are a team of 8 attorneys and we are here and willing and able to assist you in any way we can. So if any of you or your friends or family are involved in a contract that is causing you a considerable amount of stress or distress, please don't suffer in silence. Please just reach out to one of us. We are more than willing and able to assist where we can. So please take us up on that offer. We believe now more than ever we need to stand together as a community and help one another where we can. On a more philanthropic note, I think many of us, if I look at the social media posts that have been going around, feel that it's really been a time when we've been able to reflect on just how much we have and how little, in fact, we need. Having said that, it's very clear how much I need my hairdresser and how terribly short of hats I am. Mr. Jones, I know you'll disapprove, but I think we can all agree that this hat is wholly inadequate for today's presentation. So please bear with me on this bad hair day. And I ask that you just bear with us. As I said at the beginning, this is our very first webinar. So I apologize in advance if there are any technical issues. But we are committed to mastering this new form, new for us, not for many of you, technology, and that we are committed to bringing you updated information on a regular basis. So now I'm going to attempt to share my screen. Okay, hopefully you can all see that. So what does force majeure mean, and what does it mean in the time of COVID-19? Basically, force majeure is defined as an extraordinary event or circumstance that prevents the parties to a contract from performing in terms of that contract. The term force majeure, vis major, and causus fortuitus are contractual terms that are used interchangeably in sale agreements and various other commercial contracts. So if you are going through a contract that's causing you concern and you don't automatically see a force majeure clause, don't panic, dig a little deeper and see if you can't find a clause that deals with causus fortuitus or vis major, because essentially they're one and the same thing. We'll look then at examples of what constitutes a force majeure. And the first type of example of a force majeure clause is what most people, when they think of force majeure, regard as a force majeure. And those are what we call acts of God. These are extreme natural events that take place that can often prevent a party to a contract from performing in terms of that contract. And examples of this would be flood, earthquakes, and hurricanes. And the second type of force majeure, the one that people are less fully acquainted with, involves the conduct of outside third parties. So it's the conduct of outside third parties, parties who are not a party to that contract, for which the contracting parties are not responsible, and it's through no fault of their own, which prevents them from performing in terms of their contract. And examples of that would include acts of state, riots, strikes, quarantine, pandemics, and lockdowns, like the current situation we find ourselves in. So then let's take a look at the background of what this term force majeure actually means. Force majeure is not a part of our common law. Unlike many European jurisdictions like France and Germany, where it's a very entrenched part of their common law, we do not have this term force majeure in our common law. Rather, the term force majeure is a contractual term and concept, which is incorporated into many commercial agreements. For example, sales of immovable and immovable properties, commercial and residential leases, and even some employment contracts refer to force majeure clauses. So what is the effect of a force majeure clause if you have one in your agreements? Essentially, a force majeure clause excuses one or both of the parties from performing in terms of their contractual obligations in terms of that contract. It usually pauses your contractual obligations for the period of time that that force majeure remains in place. In the context of COVID-19 then, if you are fortunate enough, firstly, to have a force majeure clause at all, and secondly, a force majeure clause that either covers pandemics or acts of states, then the parties' reciprocal obligations in terms of that contract would be suspended for the period of time that that force majeure remains in place. The exact wording of the force majeure clause, however, is absolutely crucial in determining the extent of relief that the parties can seek for that force majeure period. In practice, we generally see two types of force majeure clauses. The one is what we call a restricted force majeure clause. In other words, it's been very narrowly drafted by the drafter of the contract, and it refers to specific force majeure events. So those might include fire, war, strike action, floods, and the important thing to note with a narrowly drafted force majeure clause is that if the force majeure event that you are experiencing, like COVID-19, which is a pandemic, and arguably one could argue that's also an active state force majeure that's been brought about by the lockdown, if that is not specifically mentioned in your force majeure clause, then you can't rely on the relief that it would otherwise provide. Then we get what we call broadly based, or broadly phrased rather, force majeure clauses. And these include specific events. They may include specific events and they may not. But importantly, they generally include what we like to call a catch-all phrase. And a catch-all phrase will be something along the lines of what I've stated here. Any other events arising beyond the control of the parties, rendering the performance impossible. So can you cancel a contract because of force majeure? I think that is the million-dollar question everyone wants to know the answer to right now. And unfortunately, the answer is just not a straightforward one and will depend on the actual wording of the clause itself. So cancellation will only be permitted if, firstly, the force majeure clause allows for it in the wording of that actual clause, and secondly, if it makes specific reference to a pandemic or active states, or alternatively includes a catch-all phrase. An example of this would be, should the event exceed 3 months, neither party may be entitled to terminate the contract. In most instances, a force majeure clause would rather provide for temporary suspension of the contract rather than outright cancellation of the contract. At this point, I'd like to add a disclaimer in that it must be reiterated that the implications of a force majeure clause depend on the precise wording of the force majeure clause itself. So in other words, it's very fact-specific and needs to be looked at on a case-by-case basis. It is recommended that if you are seeking to rely on a force majeure clause, please get advice from an attorney before you act on that clause. So what remedies are available to you then if there is no force majeure clause in your contracts? If there is no force majeure clause in your contract, do not panic. All hope is not lost. You can still seek to rely on the common law principle of supervening impossibility of performance. Supervening impossibility of performance and force majeure are very, very similar legal concepts and constructs, although their application and roots differ ever so slightly. So this then might beg you to ask the obvious question: if there is this common law provision of supervening impossibility of performance, why would I have a force majeure clause at all in my contracts? And the answer is quite a simple one. The answer rests simply upon the fact that the burden of proof when it comes to a supervening impossibility of performance is considerably higher than simply relying on a force majeure clause that exists in a contract. So supervening impossibility of performance does not automatically exclude a party's contractual obligations in the case of all force majeures. In fact, the following 4 conditions must be present in order for supervening impossibility of performance to become effective. 1, it must be objectively impossible, not difficult or expensive to perform. It must be absolute as opposed to relative. And what that means is that if you were to place a reasonable man in that set of circumstances, it would be absolutely impossible for him to perform. It's not relative, meaning it's not relative to the parties to that particular contract. It's objective and it's absolute. Had you to place a reasonable man in that same set of circumstances, it would just not be possible for him to be able to perform. Thirdly, it must be unavoidable. And finally, non-performance must be due to the fault of neither party. So I've just done a brief little flow diagram here because I know this is sometimes easier for people to follow on what constitutes a force majeure. So let's just recap everything I've said so far. Basically speaking, what a force majeure is an act of God. It must be unforeseeable, it must be unavoidable, and it must be outside of the control of both the contracting parties. It does not have to be objectively impossible. The clause, the force majeure clause, must be stipulated in the agreements in order for it to apply. So you can't seek to rely on force majeure and any of the protection that it offers if it doesn't exist in your contracts. There must be a link between the force majeure and the inability to perform. And the implications of a force majeure are your contractual provisions could be paused or suspended for the period of time that it remains in place, the force majeure events, or it could result in a cancellation of the contract. Neither party can sue for damages if a force majeure is proved. So then let's just have a quick look at the similarities between a force majeure and a supervening impossibility of performance. There must always be a causal link between the force majeure or the supervening impossibility of performance event and the failure to perform. There must be a causal link. There must be what we call a nexus between the two. It must be through the fault of neither party, and it may result in either cancellation or suspension of the contract. The differences then, a supervening impossibility of performance requires a much higher burden of proof than a force majeure clause in a contract. And that goes without saying, because you have to prove those 4 elements, whereas if you have a force majeure clause in your contract, you simply need to implement that clause. And obviously the obvious difference that we dealt with in the beginning is that the one is rooted in the law of contract and the other is rooted in the common law. So then let's turn to look at some practical examples, because for the majority of you who are here today, you're here to hear how this is practically going to impact on your lives and not just the legalese and theory behind it all. So I'm going to start by dealing with commercial leases, because in our opinion, this is where we're going to see the most interplay and the most impact. We all know that any contract imposes reciprocal obligations on the part of both the parties. In the case of a commercial lease, there's an obligation on the landlord to provide the tenant with beneficial use and occupation of the premises. The tenant then has a reciprocal obligation to pay rental for the use and enjoyment of those premises. So let's look then at 2 very practical examples. Let's consider the case of your favorite local restaurants. that's been forced through an act of state to close during this lockdown period. In those circumstances, the tenant is clearly being deprived of his use and enjoyment of the property, and the landlord is unable, through no fault of his own, to give beneficial use and occupation of the premises. In such a case, while it is still factually possible for that premises to be rented as a restaurant, it is now no longer legally possible for it to be let as a restaurant. So if there is a force majeure clause in place, both the parties to that contract could seek to rely on the protection of the force majeure clause, and the tenant would be absolved from having to pay their rents for the period that the lockdown remains in place, and the landlord accordingly would also be exempt from his obligations of having to provide the tenants with beneficial use and occupation. Again, I must add a disclaimer that the lease agreements between the tenant and the landlord, in that case of a restaurateur, would specifically need to cover a force majeure clause, and it would need to either include a catch-all phrase or refer to acts of states, which arguably, or not even arguably, the lockdown is, or a pandemic. We'll then also turn to consider another example, which must be clearly distinguished from the first, and that is with regards to essential services. So a grocery store or a pharmacy, for example, a force majeure clause cannot be relied on to excuse those parties from paying their rent, as there's no causal connection between the force majeure event, the COVID-19 pandemic, and their failure to perform. Then we'll turn to consider residential leases, because we have had a number of queries with regards to this. And for the most part, we believe there should be very limited impacts in the residential lease space. And the reason I say that is that for the most part, people are locked down in their residential homes. They are unable to move and still have the beneficial use and occupation of those premises. Where COVID-19 might have a practical effect, however, is that for new leases that were perhaps entered into in March or even in February, where the tenants were due to take occupation sometime in March, it is now physically and legally, objectively impossible for them to take occupation of those premises, and the parties can seek to rely on either force majeure or look at supervening impossibility of performance as an alternative form of relief. So practical suggestions then for tenants in the commercial space. We would like to say that communication, as always, in any relationship is absolutely key. These are unprecedented times, and contracts can always be renegotiated between the parties. So our advice is to ask tenants to please approach their landlords about utilization of a damages deposit, perhaps a payment holiday or deferment of rental. Don't act unilaterally and take the law into your hands. Rather, enter into communication with your landlord and take it from there. So we're going to turn now to consider the last aspect, which deals with COVID-19 and the various contractual scenarios that it poses for sale agreements. What does all of this mean in the context of sale agreements? And for many of us here today, we are agents or property law practitioners, and this is something that's a question that's very hot on all of our minds because it affects our livelihoods. And can a party to a sale agreement cancel because of a force majeure clause, or alternatively on the grounds of supervening impossibility of performance? Simply put, you must ask yourself the question, is it actually possible for one or both of the parties to perform? If the answer to that is yes, which we believe it will be in most cases, then absolutely not. The purchaser or a seller cannot seek to rely on supervening impossibility of performance or force majeure. Remember, delay or difficulty in performing does not make it impossible to perform. Having said that, I'd like to say that care must be given to look at the agreements as a whole, specifically where agreements are awaiting the fulfillment of suspensive conditions. They may contain what we call a material or adverse change clause, which allows the party to terminate the agreement if a material or adverse change in the circumstances arises prior to the fulfillment of that suspensive condition. We also know, practically speaking, that COVID-19 has had very dire effects and consequences on the economy. As a consequence, purchasers may seek to invoke the protection that's afforded to them in terms of the National Credit Act. And an example of that would be when purchasers go in to sign their bond documents with the bond attorneys. We all know that the bond attorneys are required both in terms of the National Credit Act and in terms of their various service level agreements with the banks to pose the question to the purchaser: have your financial circumstances changed? And if the purchaser responds by saying, yes, I've been retrenched or I've been placed on short time, you can pretty much rest assured that the bank will pull that bond. So that brings me to the end of today's seminar, or rather webinar, on force majeure in the time of COVID-19. I do hope that it will have added some value for you all. I have got my email address up here on the screen. Please don't hesitate to email me any questions or queries you may have. I'm more than happy to assist, and I will get back to you as soon as possible. In the interim, please look after yourselves and stay safe.